Hello friends and welcome to StudyIQ. I am Joy and today we will be discussing about the Madras High Court ruling on child abuse and also the relevance and the need for sex education in schools. So we will be discussing this topic in detail in this lecture. We will discuss about a current judgment given by the High Court of Madras, and also based on that we will see why is sex education very important. So let us begin with the current affair. Let us see what is the current affair. So recently the Madras High Court has given a judgment on a child rape case, and in the child rape case, the Madras High Court held up rigorous imprisonment, that is a rigorous punishment for a child rapist. So apart from giving this judgment or this verdict, the court also made some very important observations, some key observations, and these observations we will be analyzing in depth and which will give an insight about how to handle such cases and also the need and relevance for including sex education in the school syllabus. So we will be discussing this in detail. So first, coming to the case, let us see what is the case all about. So the Madras High Court, the High Court of Madras, was hearing a case in which a man had sexually assaulted a 5-year-old girl in the Nagapattinam district or Nagapattinam in Tamil Nadu in the year 2011. So first thing you must note here, so let us just keep in mind the year 2011 because we will be coming back to it later in this lecture. So we will be coming back to this year. So keep in mind it happened in 2011. So the Madras High Court was hearing a case on sexual assault of a 5-year girl. So definitely this will come under POCSO Act. According to the case, a man called Ganapati, so this is the name of the person, Ganapati had raped the girl when she was playing with her friends. So based on the complaint given by the mother of the child, so girl's mother had given a complaint. So the Nagapattinam police, they registered an FIR against the Ganapati, this man, for the rape. So this is the case. And what happened? While the court was giving the judgment, Justice S. Vaidyaratnam, he was the justice who was delivering the judgment. So Justice Vaidyaratnam, he was giving the judgment, who was hearing the case. He junked several arguments made by the defense on the basis of technical lines. So the defense had argued various things based on technical lines, but the judge had junked these arguments. So this is the case all about. Now let us come to the observations made by the judge. So the first one, the judge had overruled several arguments made by the counsel for the accused in the case. So here we need to understand what is counsel, who is the accused, and all that technical terms. So counsel refers to the advocate or the lawyer who appears for the accused. Now accused is Mr. Ganapati. So he was the person who was accused of this offense. So the counsel or the lawyer, the advocate who appeared for Ganapati, the accused, he made certain arguments for the accused. So the judge has overruled certain arguments. Let us see what are the arguments. The first one, the initial delay in filing the case or the complaint. Second one, the absence of injuries in the child, and the third one, the trustworthiness of the victim's statement. So these were the arguments put forward by the counsel or the advocate who appeared for the accused. So first argument he put was the case, as I said in the beginning, just remember the date. I told you have to remember the year. So it happened in 2011 and now it is 2019. So the first argument by the lawyer of the accused was that there was a delay in filing the complaint. So that must be considered. Second one, there was no injuries to the girl. So that is the second argument put forward by the lawyer of the accused. Third one, the lawyer also questioned the trustworthiness of the victim's statement. So these were the three things. But what happened? The judge who was hearing the case has overruled several of those arguments put forward by the lawyer. Now, let us come to the important points. The first one is the delay. So, the defense side, that is the lawyer of the accused, the defense side argued that the mother of the girl, the mother had delayed the filing of the complaint. So, this was one argument put forward by the lawyer of the accused. So, For this argument, the judge said that the rape of a girl of a tender age, because she was just 5 years old, so a girl of tender age will have adverse effects which her family needs some time to recover from. So when a girl who is of 5 years, when that girl is physically abused or sexually assaulted or raped, then the family definitely would be going through a trauma. So it will take some time for the family to overcome it. So the delay in filing the complaint is just natural. That was the statement given by the judge. So the judge said that the delay of filing the complaint, this is very normal to human conduct. And another observation made by the judge in this regard was that the girl was from a village. So in a village setting, neither the girl nor her parents would be tempted to rush to the police immediately. So these were the observations made by the judge, which is very appreciable. Now, second argument put forward by the lawyer of the accused was regarding the injuries. So the lawyer argued that there was an absence of external injuries in the girl child. So for that, the judge said that it is not possible to find blood stains on the girl's body 4 days after the rape. So this was the statement given by the judge. So we will see that the judge was in favor of the victim. So this is how the judges need to be. This is because at times it is not the evidences or the factual data or some scientific evidences that should act as a base for giving certain judgments. So judges will have to consider the circumstances and situations as well. Now the third one was regarding the trustworthiness of the victim. Here the judge stated that the courts have to believe what the child survivor says in such cases. So the court was in favor of the statement of the victim. So judge said that in such circumstances the court has to believe what the child survivor has to say. So here the judge made it very clear that the court should not be influenced by misconceptions that children are likely to lie in cases of sexual abuse. So there is a misconception that in cases of sexual abuse children are likely to lie. So court said that we cannot move forward with this misconception. This is just a misbelief. And the court also made an observation that children should also not be seen as being tortured by the parents to make false statements. So the court's observation was that the misconceptions like the parents torture or the children would be lying, such kind of misconceptions should not affect the manner in which the courts respond to cases of child sexual abuse. So these were the observations made by the court, very, very relevant. So when you write an essay about the protection of girls, children, or any such kind of social issue related essay or any answer, you can definitely mention this judgment and observations of the court. So here the court was being very sensitive and the court was considering the situations rather than the evidences. Now let us see what are the guidelines for the defense lawyer's interrogation. So here we have seen that how the defense lawyer has appeared in the court. What were the arguments made by the defense lawyer? A defense lawyer is the lawyer of the accused. So how did the defense lawyer appeared himself on the court and what were the arguments made? So we will see what are the guidelines or how should the defense lawyer's interrogation be. So first one, when we look at the defense lawyer's arguments, not only in this case, in many previous cases, we will see that there is a structural problem in the legal system. This is not how the defense lawyers should deal with the interrogation, especially when it comes to interrogating children or women or vulnerable sections. It should not be the way how it should be. So in most of the times, the interrogation of the defense lawyers are biased and also derogatory towards the victims of child sexual abuse. This is because the questions, the defense lawyers' questions are very hostile and they are, most of the times they are sexually explicit and most of the time these questions are structured in a way that the lack of resistance means consent. For example, we have seen many times, at least in movies you would have seen, the defense lawyers would be asking questions for which the children will not be able to answer, and they will make it a point that not answering the question or not resisting to it, it means simply an yes. So most of the times we have seen that, and in courts many of the time the defense lawyers make the vulnerable groups, especially the children, unanswerable, and they make it a point that they argue on it. So the same has happened. So this structural issue should be resolved. And when we talk about the guidelines has been given in 2004 in the Sakshi versus Union of India case. So certain guidelines were given, and this guidelines aim at discouraging this controversial practice given by the defense lawyers or the defense counsel. So what are the guidelines? The guidelines say that the cross-examination, that is the cross-examination of the victim, should be done by the presiding officer. So the presiding officer should carry out the cross-examination of the victim. So this is to ensure that the vulnerability of the victim is not utilized or taken advantage of. So this will also help in preventing any kind of harassment or any kind of intimidation by the defense counsel. So to prevent harassment and intimidation by the defense counsel, the guideline says that the interrogation must be carried by the presiding officer. So these are the guidelines given. But what we see in practice, in reality, is that in practice this does not happen. So in practice, most of the time the cross-examination gets unacceptably offensive and objectionable. So these guidelines are not followed practically in many cases. So this is what we will see. Now let us understand how is a child's vulnerability a limitation here. So first thing is that the child witness, most of the time they do not understand the confusing questions that the defense counsel asks. So if we take the case that we are discussing now, the child is just 5 years old. So the child is not mature enough to understand what is the question asked by the counsel. So that is one way by which the defense counsel will make use of the vulnerability of the child. Now second one, this makes them very much vulnerable, and when they don't understand the questions, they will start giving very vague answers. So these vague answers, the defense counsel will take up for argument. So this is what happens. Now thirdly, the children's delay in case of disclosure of the abuse, it is very common. This is because most of the time the children who are of very young age, they even disclose such type of abuses to the parents at a later stage. So this is very normal that the complaint get registered in a delayed manner. This is because the children itself will report it to the parents in a later stage, and the family has to overcome the trauma of it. So the delay is very natural, and because the delay is natural, there are chances that the medical evidences also go undetected or they get lost. So the court cannot always rely on medical evidences. This is because in most of these cases there is a delay, and therefore the medical evidences can also get lost. So it should be made a point that just because there is an absence of a medical evidence, that the justice delivery should not get impacted. And now this delayed disclosure also makes it very difficult for the child witness to recall specific details of the abuse. And when the witness is unable to give the details of the crime, then the defense lawyers make it a point to win their case. So all these points put together, these highlights the need to have a policy in place. We need a comprehensive policy in order to deal with such type of issues. For example, to address the concerns of delayed reporting, and also regarding concerns regarding the cross-examination of the child witness. So we need to have a comprehensive policy to address all these issues. Now, why is sex education or sexuality education important? What is the relevance, and how will sex education help in this regard? Now, first of all, this will help in narrating what exactly happened to the child. So children will be able to exactly narrate what happened to them. For example, to use the names of certain body parts, to use the correct names of the private parts. So, sex education will help children in that. This will also reduce the shame and stigma associated with talking about the private parts or with regard to some of the body parts. And sex education will also help the children talk about the nature of sexual abuse, what really happened to them. They will be able to use the right vocabulary. And also this will help children to recognize potentially some inappropriate behavior. So they will be able to realize or recognize if someone is behaving inappropriate to them. And also this will help them understand some different emotions that come with feeling unsafe. Like for example, if somebody is touching them with a wrong reason, then they will definitely be able to make out that they are unsafe. So for that reason it is very important. And also this will help the children to seek help from adults or parents or teachers. So in all these regards, sex education, providing sex education from the school level itself, it's very important and it should be made a part of the comprehensive policy. You can find the PDF of this lecture on our website www.studyiq.com. You can follow my Facebook page for more video updates. You can write to me at joyce.studyiq@gmail.com for any of your queries and clarification. Thank you.